In this lecture, I want to talk about the political dimensions of judicial activism and judicial restraint, because the two schools of thought have been associated with liberalism and conservatism. Since the 1930s, and especially since the Warren Court in the 1950s, liberals have generally been seen or been portrayed as activists, whereas conservatives say that they practice judicial restraint. So that's the way it's been for almost 100 years. And in fact, you can hear it in the way liberal and conservative presidents, Democratic and Republican presidents, talk about the kinds of justices they'd like to nominate to the Supreme Court. Liberals, Democrats, tend to say that they want judges who would support a living constitution, whereas conservatives often say that they want judges who will interpret the law, not make it, or that they won't legislate from the bench. They want judges who will not act like legislators and will not legislate from the bench, as seen in this clip from George W. Bush.
Every judge I appoint will be a person who clearly understands the role of a judge is to interpret the law, not to legislate from the bench.
However, although liberals have been associated with activism and conservatives associated with restraint, there's actually absolutely nothing inherently ideological about activism or restraint. Liberals can be activists, but they can practice restraint. Conservatives can also be activists. Whether or not an activist is liberal or conservative depends on the ideology of the law that they are reviewing. If the law is liberal and a conservative strikes it down, well, then they are being activist. And if a law is conservative and liberals strike it down, then they are being activist. It just so happens that over the last 50 to 70 years, there was a period, certainly in the 50s, 60s, and 70s, in which the liberal Warren Court, and to a certain extent the early Rehnquist courts, were striking down lots of conservative laws, such as anti-abortion laws and so on and so forth. So, in fact, the identity of conservatives and restraintists have changed over time. Before 1937, it was the conservatives who were activists, and we'll talk about that a little more, but in fact, it was the five activists on the court that continued to block the liberal New Deal legislation. Those conservatives, they were being activists because they were imposing their own views on the country. Now, following 1937, the tables turned. The liberals were associated with activism and conservatives preached restraint because, again, they didn't like the fact that the court was striking down a number of conservative laws. But in the 21st century, the tables have flipped again. And the reason for that is because conservatives now have a majority on the court, and it tends to be whichever group has a majority on the court, they tend to embrace activism. If you have a minority on the court, you tend to embrace restraint. So this is entirely political, although it's couched in terms of democratic theory. Both liberals and conservatives are opportunistic when it comes to which ideology they're going to adopt. So let's talk a little bit about what kind of activism separates liberals and conservatives. Well, liberals do engage in activism, but they do so on behalf of economic equality and regulation. So they typically uphold laws that try to equalize the playing field and strike down those that try to exacerbate economic inequality. So they tend to uphold laws that regulate business, and they tend to promote laws that promote economic fairness, such as perhaps affirmative action. They tend to practice restraint then with regard to laws that do these things. So if Congress passes a law that regulates business or helps labor unions in some way, then, or sets maximum working hours or a minimum wage, well, then liberals will look on these laws with favor, they will uphold them, and they will be seen as practicing restraint. But of course, they oppose laws that regulate private moral behavior. So laws that regulate things like abortion or private sexual behavior or gay marriage or the right to die. Liberals tend to oppose laws that restrict these things, and therefore they tend to strike them down, and they are called activists when they do so. Conservative judicial activism, of course, is exactly the opposite, because conservatives do not generally believe in economic equality, and they generally don't believe in governmental regulation. And therefore, if Congress passes laws that regulate business or help unions or workers, they tend to strike those laws down, and they're activists on those laws. But of course, they tend to practice restraint regarding laws that are friendly to business or hostile to labor unions. And conservatives, of course, tend to support laws that regulate private moral behavior. So they like laws that regulate abortion, that regulate drug use or homosexual relations, and so on and so forth. And as a result, conservatives tend to practice restraint on these issues. And in fact, it was Roe v. Wade and a lot of other social cases where liberals were deciding in a liberal direction that led conservatives in the 50s, 60s, 70s, and 80s to call them activists. But of course, that's not the way it always was. Before 1937, the court was activist, and it's important to understand this period because we are entering another period just like what was happening before 1937. Before 1937, it was conservatives who were activists because they invented new rights that were not contained in the Constitution. And this is one of the things to think about, because you may be a liberal, you may believe in the right to privacy, you may believe women have a right to an abortion, but the question is, where did that right come from? And if the court can create that right, can't they create other rights? Where could the court possibly stop? And the court may create rights that you do not agree with, that lead to outcomes you do not agree with. And so what did they do? Well, in a very famous case of Lochner v. New York in 1905, New York had passed a law limiting the number of hours that bakers could work. This is a very common kind of law that we have nowadays. You have, minimum wage and maximum hour laws. But in this case, the Supreme Court, a conservative activist court, struck down this law using something that they called the liberty of contract. They said that it violates the constitutional liberty of contract. The only thing is, there is no liberty of contract mentioned anywhere in the Constitution. So in this way, liberty of contract is very similar to the right to privacy, because neither one of them exists in the Constitution, and the only reason they came into being was because a number of justices on the Supreme Court said that it existed, and then they used that concept to strike down laws that were passed by democratically elected majorities. So it was this theory, the liberty of contract, that led the court to strike down not only state legislation, but also the federal New Deal legislation that led to the crisis where Franklin Roosevelt proposed adding justices to the Supreme Court because they continued to strike down his laws. Now, of course, you know that in 1937 the court switched, one member of the court switched, and they started to uphold his legislation, and so overnight they went from being activists to practicing restraint. But the court was embroiled in conflict because it was engaged in conservative judicial activism. Now again, from 1937 to the 2000s, liberals tended to be activists. Now they tended to uphold laws regulating the economy, as we've mentioned, because they like those. But they tended to strike down laws that regulated free speech and private behavior. They also tended to pass decisions that were friendly to criminal defendants, individuals who'd been charged with crimes. They passed or made many decisions that were aggressive, of course, against racial discrimination. The Brown v. Board of Education decision was charged with being an activist decision. And they also insisted on a strict separation of church and state, while at the same time demanding greater support for minority religions or greater freedom for minority religions. And all of these things were perceived of as being activist. Now, the ideological basis of the liberal activism came in one of the two most famous footnotes ever in Supreme Court history, footnote 4, which was in an otherwise unremarkable case called U.S. v. Caroline Products. And in this case, the court upheld a law that regulated the economy, but in doing so, they mentioned something in passing. It seemed to be in passing. It's just a footnote, but it turned out to be extremely important. Footnote 4 says, "It is unnecessary, in this case, to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are most other types of legislation." So what the court was saying, and it continued, "Nor need we inquire whether similar considerations enter into the review of statutes directed at particular religious or national or racial minorities, whether prejudice against discrete and insular minorities may be a special condition which tends to seriously curtail the operation of those political processes ordinarily to be relied upon to protect minorities, and which may call for a correspondingly more searching judicial inquiry." This may sound complicated, but what footnote 4 is saying is, well, you know what? We upheld this law, but when it comes to other kinds of laws that restrict individuals' fundamental freedoms, or laws that injure or restrict the rights of minorities, religious, racial, or other kinds of minorities, we might take a much closer look at those kinds of laws. In other words, we may practice restraint in some kinds of cases that involve economic issues, but in cases that involve fundamental rights or discrimination, we will not be as deferential. They didn't use the terms activism or restraint. The court almost never does, but that's what he was pointing out, was the difference. He said we'll be restrained in economic issues, but activist in other issues. And this also presaged the strict scrutiny test that the court started to use a few years later in cases involving racial discrimination. Now, what's happening today on the Supreme Court, as I indicated, is the court is returning to the era of the 1930s. And of course, that is because conservatives now have a solid majority on the court. And so they have become activist once again. They have struck down a series of laws, and this court is exceedingly friendly to business, striking down virtually all laws that regulate business, while on the other hand, they tend to also strike down laws that help minorities. So they are an activist court, and they've done it across the board. They've been active, although they did not strike down Obamacare. They've chipped away at it, and they've accepted cases that they didn't have to. The Citizens United case is a great example of activism because, of course, legislation designed to curtail the influence of money in politics was struck down by the court. The court, of course, in their gun control decisions has also been activist. They've taken an expansive, probably inaccurate view of what the Second Amendment actually meant, and they've used it, of course, to strike down one piece of pro-gun legislation after another. And so the problem, of course, is that we have entered the 1930s again. You have 5 conservatives on the court, 4 liberals on the court, and if a Democrat is elected president and there's a Democratic Congress in 2021, They may pass all the progressive legislation they want, but they may see it struck down again and again and again by a 5-4 conservative majority, a conservative majority that is activist. And all of a sudden you may see liberals once again discovering the virtue of judicial restraint.